Silicon Valley. And in this opportunity, I want to invite Daniel Green, who is from the GTLaw, and he focuses his practice, he's a lawyer, assisting private and public companies, especially startups. They have a very interesting program on products for startups, and something that is very tricky when you are Latin America, is Latin American startup, is how to land successfully in another law environment. Yeah, but what's going on about your immigrations, rules that you have to abide, how to land successfully, and sometimes something that we overestimate or subestimate about how to do the homework fully. Well, thank you for coming.
Thanks very much. I guess I'll just use this. Pleasure to be here, and like Esteban was just saying, for me in particular, I love helping Latin American entrepreneurs come to Silicon Valley and beyond and access the markets here and capital, etc. I'm one of the few attorneys in Silicon Valley that kind of focuses the majority of my work on the region and building bridges. And I had the opportunity to work with Esteban on one of his companies. And so for me, the job really is about helping position companies to maximize their potential. And I work primarily with hybrid companies. So I work with the companies that Esteban mentioned, where you have maybe your development team in places like Argentina, Chile, and you have a small presence in Silicon Valley, San Francisco, to help establish your U.S. commercial office and your market and your fundraising, etc. And oftentimes the approach that one takes there is to try to make yourself look and feel like a Silicon Valley company. The world is changing, and VCs and angel investors are now willing to invest in companies where the development team and the origins of the company are outside of this region. But as long as you look and feel like a Silicon Valley company, and we can talk about what that means, then you really position yourself for a more frictionless process down the road, whether that be fundraising, whether that be entering into a strategic partnership, whether that be selling yourself. And so that's what I do, that's what I work on. I want to make this interactive because lawyers are generally a necessary evil. We try to be in the background as much as possible and be helpful whenever possible. And there's plenty of pitfalls, and there's plenty of different things that can happen along the way to kill a deal or to prevent a fundraising or a sale. Small anecdote on that. I had a good friend of mine who was in sale discussions for a startup recently, and they were about 3 days away from signing the acquisition agreements, and he said that there was a specific due diligence issue that came up where it was a license agreement with what's called a patent troll. I don't know if you've heard that term. It's a term where there's specific IP holding companies that don't have a product or service to sell, but really all they do is hold patents and ask for licensing fees or sue for infringement. And that's what they had entered into here. And this came up very late in the process. And the buyer asked for a lot of documentation to understand this arrangement better. And it started this unraveling yarn where one thing led to another, and the buyer got spooked, and then they asked to renegotiate the agreement, and they couldn't do that, so the buyer pulled out. There were other buyers who had been interested before who then got spooked, and then they couldn't sell the company, and then they couldn't fundraise anything. From month 1 to month 3, they went from selling the company for a nice exit to shutting down the company. And my poor friend doesn't know if he's going to get his last paycheck. So that's illustrative of trying to be out in front of legal issues from the get-go. If you can keep your corporate governance, as Esteban mentioned, in front and center, if you can make sure your corporate housekeeping is done well, and know in what direction you're going to be well served for the future. So some of the initial questions to think about when you're approaching lawyers is, in particular, where do I want my company to head? Do I have a global company? Am I primarily going to be servicing the US market? Or am I going to be servicing the Latin American or other markets? And where do I think my fundraising sources are going to come from? Because those questions are largely going to dictate some basic steps that you take. Where do you set yourself up? What type of legal structure do you set up? Do you set up a C corporation? Do you set up an LLC? Do you set up in Delaware? Do you set up in your home country? For the most part, the companies that I work with that are looking to fundraise here and that are US-centric or global will create a US holding company, oftentimes a C corporation, which is the funding vehicle of choice for venture capital, with a subsidiary in their home country. There are exceptions to that rule, and oftentimes the LLC rather than the C corporation is used when you have much of your operations outside of the US. But that's sort of the basic structure. And then the second question is understanding where, the corollary to that question is understanding where your IP, if you're an IP-intensive company, where your IP should be located. And keep in mind that the US tends to think of IP in much broader terms than traditionally in Latin America or other countries. So IP isn't just trademarks, patents, domain names, it's know-how, it's design work, it's anything in the head of your employees that gets contributed, it's customer lists. As a result, the standard here is to have every single person who does any work for you, for your company, whether they be an employee, an advisor, a contractor, a director, sign what's called an IP assignment agreement, or a PIAA. They have a variety of different names. It's the same sort of function. It assigns IP to your company in a very broad way. And one pitfall that I see a lot is, I had this issue come up with a Spanish company recently, where they were created in Spain in 2007. They became a hybrid company with a US holding company. And when they were created, they had 30 developers working on their IP over a 2 or 3 year period. Some stayed with the company, some left. The company then came to the US and fundraised. And of course, the investor and their lawyers asked, well, have you had all those people sign IP assignment agreements? And the answer was no. And then the next question was, well, can you get them to sign now? And when there's been a period of time that's passed, 1, 2 years, maybe somebody left on not the best of circumstances, it can be challenging to have them sign agreements when they have no incentive to do so down the road. And in the acquisition context, rather than the financing context, what that means is oftentimes the shareholders of the company will bear exposure for that if the IP wasn't assigned properly. So keep that in mind. Be very diligent about protecting your IP. Be diligent about documenting the assignment of your IP to the company so that you have a clear chain of title or clear chain of ownership down the road. Another pitfall to think about is equity and maintaining very clear visibility over what's called your cap table, your capitalization. Who owns your shares? Who's been promised your shares? Who's been promised notes that convert into shares or warrants that convert into shares? And making sure that any promises that have been made, any verbal arrangements, hey, great job with that, go for it. I'm gonna promise you 10,000 options once we get funded. Those sorts of things can be very costly to clean up down the road. Another case in point, illustrative of this, is had a company, actually not my company, a partner's company was in the process of selling itself. And they were going through what's called the funds flow. At the very end of the process, you'll work through a spreadsheet that shows who's getting what as part of this deal. And it lists out all the shareholders, if you have note holders, etc. The CEO was sent the Excel spreadsheet based on the records of the company, and said, everything looks good to my friend the lawyer, except for one thing. Where are the president's shares? And my friend said, what president shares? You've got common stock, and you've got preferred stock, and you've got all of it listed here. He said, well, you know, I've got these president shares in my vault in my office, and I've been handing them out over the last couple of years as a kind of bonus and a slap on the back for people who've done a good job, who've performed well in different projects. And my partner was taken aback to, well, okay, hold on, who have you promised that to? And it turned out there were about 5% of the cap table had been promised, unknown to anyone else, to individuals along the way who had done good work for the company. What that turned into was, you know, having to pay them off, having to get releases of claims from them, because that's what the buyer wanted. So you really need to be clear about what, who owns what of your company, be very disciplined about promising equity. A fundamental part of the culture here is the culture of equity and working for options or restricted stock or shares that vest over time. In Latin America, the culture of equity historically has been evolving, and I think over time, to the extent we see more exits, we're going to see more cultures of equity. But making sure that you really keep a handle on what you've promised to people is important. The other pitfall to think about is labor law compliance, and making sure that in your home country and in the U.S. you're adhering to local laws. And in particular, the issue comes up around who's a contractor and who's an employee, who's a consultant and who's an employee. And where you have an early stage startup that is cash strapped, it's oftentimes very common to bring people on, to not bring them on as formal employees for a period of time, and then convert them. The expectation is they'll be converted to full-time employees after a period of time or after you raise capital and get traction. And that's common, it happens a lot. Where that comes back to bite you or be harmful is when that period extends over months or even years, and that number grows from 1 to 5 to 10 to 20 or more, and it never gets regularized or documented. Had a company going through a Series D funding 2 weeks ago, raising $30 million from a later stage VC here, nice valuation, and this issue came up, and they quantified the exposure from their past non-compliance at €500,000, which was eye-opening for the investor and took a lot of explaining to that investor to get them comfortable with that. So keep in mind your labor law compliance, keep in mind who you're working with, what their rights are under local law. Do they have statutory severance obligations? Do they have statutory bonus obligations? How do you make sure that if you're treating them as consultants, the auditors, the regulators will treat them as such? And making sure you work with good lawyers, both locally and in the holding company jurisdiction, to make sure that that's dealt with. So those are some of the pitfalls that I see a lot. There's any number of other pitfalls that you need to be aware of. And the role of somebody like me is to make sure that you go in with your eyes open and you understand legal risk, and you make sure your corporate governance and housekeeping is taken care of, so that you anticipate those issues down the road. Hopefully you don't have those issues. You anticipate them, and you have a very clean company to present to the VC or to the buyer. That's the ultimate goal. Lawyers are expensive. Lawyers are seen as a necessary evil oftentimes. The best way to work with a lawyer is to establish a rapport and a long-term relationship. And for people like me and others in the audience that I see, it's really about the relationships. I get really excited with working with entrepreneurs who are passionate about their projects and their vision for the company. And when I'm investing in a relationship, I'm not going to bill every single minute of my day helping that visionary, that entrepreneur, and that's the relationship you want to try to establish. You want to have chemistry, not only with your lawyers and your VCs, but everyone around you. And so in that situation, you keep your lawyer involved, and he or she should be able to tell you, look, I'm not going to charge you to do this, or I am going to charge you, it's going to cost X or Y. And so you have a good relationship and an open, frank discussion with your lawyer, instead of thinking, gosh, this is, I don't want to send this to my lawyer because I know he's going to charge me, or I know it's going to be expensive to work through, so I'm just going to keep this, I'm going to clean it up myself, and then if it becomes a bigger issue, I'll bring him or her into the loop. That can be disastrous. So keep folks like me in the loop and really working alongside the founders and the team in the same way to make sure that everyone is aligned in incentives. So those are some of the thoughts. I want to make this interactive. Like I said, I want to open this up to questions specifically on the minds of you guys. So what specific legal topics do you guys want to cover? Or any particular questions that you guys have faced in your companies? Yeah.
What about the terms to raise capital when you have an angel investor and then when you have a VC?
Yeah. Great question. Question is, what sort of terms should you think about when you're raising a follow-on round and you've raised money from an angel investor and maybe now you're raising money from an institutional VC? How should you approach that? And it's a great question. Oftentimes, angel investments take a variety of different flavors these days. They can be equity, they can be early stage equity, which is oftentimes called Series C or C stage. They can be convertible notes that convert into equity upon a later fundraising, like the one that Alto is mentioning, or they can be straight debt in certain circumstances. Making sure that your seed round, your angel round, has been done in a way that is familiar to the VC who comes on later is so important, because that's another opportunity to have a frictionless process down the road. So there's the beauty of what's happened over the last couple of years is standardization of legal documents in this area. You've got kind of an open source movement where on the internet, widely available are standardized set of equity documents and convertible note documents that get used for angel investments. And those terms are widely accepted. There's a few points that get negotiated oftentimes: valuation in an equity deal, on a convertible note deal, whether it's what's the discount, is there a valuation cap, what's the interest. But that universe of discussion points is greatly reduced when you use those standardized documents. And as a result, your VC here, or an internationally minded VC in Latin America, is going to know those documents, and it's going to be very easy. And then the question is really only around, well, what's the dilution that's going to be borne by the angel investor? And what percentage is the VC going to own? The angel investor, for the most part, takes a lot of risk. They're investing at the early stages of the company. And the fear in the back of the mind of the angel investor is oftentimes, gosh, I'm going to get squeezed, my ownership percentage is going to get greatly diluted over time. I don't have a lot of financial wherewithal to invest in continuous fundraisings, and so I'm going to get squeezed. So if you keep that in the back of your mind and you anticipate those concerns when you're negotiating with the VC, and maybe you tell the VC, look, we've got a great angel, he's been super helpful, I want to make sure he or she gets treated right. And so while the valuation isn't what we were hoping for, it's acceptable to us, I can convince our angel to come on board, to agree to that. But I want to make sure the angel gets a pro rata right. Even though he may not have contractual rights to do that, I want to give him the opportunity to invest in this deal. Or maybe a small warrant where you give him some upside for supporting the deal. Making sure that both your VC and your angel investor in that context are taken care of is very important, because many companies, many angels have been burned by situations where they've invested in a company, they've taken risks, that company has been successful, but their 5% ownership has been shrunk down to 0.005% at the time of the sale, and they hardly get compensated for the risk that they took up front. So you have to keep those points in mind. Make sure you use standardized documents. One of the things that I have seen in Latin American countries over the last couple of years is a willingness by local VCs in Chile, in Argentina, in Brazil, to use Silicon Valley style legal documents and to structure their companies to look and feel like those companies. So that has then led to a number of follow-on investments. I just represented Flybridge Capital making a Series B investment in Restaurando. Just got announced a couple of weeks ago. That process was incredibly easy for us and for Flybridge to get their arms around, because the earlier investors, had set the company up in a way which was very familiar to everybody, and they had done the hard work. And there's Chilean VCs that are doing that. There's a number of VCs in Mexico that are doing that. And I think that's the type of partner. If you have a global or a Silicon Valley mindset, those are the local partners that you want to work with.
How you can deal with the other guys, with the guys that are not playing the same set of rules?
Yeah, that's a great question. I mean, we live in a competitive marketplace now, right? And so, Buenos Aires, hopefully with Mariano's help, we're going to have more competition for fundraising. We're seeing that in other markets. And when, no longer is it the case that there's one or two VCs in a market who can dictate terms and can take majority ownership in a company in a Series A round, where they're going to control the board and have all sorts of controls. You have an open marketplace, and you have the ability to talk to folks here, and you have the ability to talk to friends who have raised capital here to understand what the norms are. What are the terms that we think are within the market for standard venture capital investments? And you should think about, getting a competitive process going. And if you're in that fortunate position to get a term sheet from a local investor, but the terms are, on first blush, what you think is very pro-investor, talk to your friends who are the local lawyers, talk to people who are here, talk to entrepreneurs here, and understand, is this standard or not? If it's not standard, don't be shy about going back to the investor and saying, look, I'd love to work with you. I think you're going to have a lot of value. Frankly, I can't get comfortable with these terms for X, Y, and Z reasons. And ideally, you have another investor who's interested who you can sort of get them to move off of, or get them to align their term sheet more in line with Silicon Valley standards.
You were talking earlier about employee equity and keeping track of what you promise to people, and I'm curious. I mean, I think it's a very positive trend that early employees are getting shares in the company, and I'm curious, from the deals that you've done, what are some of the more successful and maybe creative, maybe not creative, maybe it's standard, in terms of employee option pools or equity sharing with your early team, and when you make those decisions, what does that mean for you when you get to the stage of doing fundraising? What should people keep in mind when setting those up early on?
Great questions, and it really depends on, first and foremost, you have to understand your employees and your advisors and your folks that are helping you. Are they motivated by equity or not? Are they motivated by cash? So I have companies in Colombia, for example, who know that most of their employees below a certain senior tier aren't really motivated by equity, and it's understandable. There's not a track record of exits that they can validate to understand the value of the equity. So they use cash bonuses, they use phantom equity, so it sort of looks and feels like equity. It has vesting, that you can earn the right to that cash component, that cash bonus over time, but it's not absolute equity. But if your employees are motivated by equity, then you need to understand what's the best way to set it up. Is there a tax-advantaged way to set it up? The U.S. has tax advantages for stock options. There's two different types of options. There's ISOs, which are incentive stock options, which have tax advantages. Basically, you can get a lower tax rate on the sale of those underlying shares if you meet certain requirements. 2 years holding period, 1 year after exercise. It can be hard to meet that, but you get capital gains tax treatment. The other type of options are NSOs, non-qualified options. Most other countries around the world don't have those tax advantages. And some countries tax option grants at the time of the grant, rather than the time that you exercise and sell your underlying shares, which can be very punitive for your employees. So if you're in a situation where you know your employees value equity, and you have employees in different parts of the world, make sure you understand the tax structure for that. Because there's not only stock options, there's restricted stock units, there's different flavors of incentives that you can put in place that create the same alignment of incentives, but that don't necessarily produce punitive tax results. Make sure your vesting terms are very standard. Vesting, as I've mentioned before, is this right where you have to work for the company, you have to perform services for the company and add value over a period of time. There's very standardized vesting schedules in Silicon Valley. This goes to partly what's the look and feel of a Silicon Valley company? Well, oftentimes it's one where the founders have vesting and all of your employees and advisors have vesting. And there's a lot of art to how you set up the vesting, what sort of triggers are there for acceleration of vesting. How do you get protected if you're a founder and you get terminated, and you bring on a VC or investors, you don't necessarily control your board, you can get fired. How should I be protected for that? Well, oftentimes one of the ways is vesting acceleration, but not being so greedy or so aggressive on setting up your vesting that you're going to create tension or friction or renegotiation at the time of an acquisition or fundraising. So work with a lawyer who understands what the market parameters are for vesting, and make sure everybody buys into that concept, because sometimes it takes a little bit of explaining.
It seems like often the role of a lawyer is thinking of everything that can go wrong in the company, while the entrepreneur is playing chess while riding a roller coaster and focusing on the only thing that is going right. So how do you reconcile those mindsets, and is that a source of friction?
It's a great question. Lawyers are trained to think of the parade of horribles out there. People like me, transactional lawyers, are oriented around risk and control, basically. And so we tend to see that risk that's in the corner there, where it's a 1% chance of happening, but if it happens, it's going to be catastrophic. So the way, and you're absolutely right, there's a philosophical approach that is different for a founder. So what I like to do is basically, be very realistic about and very pragmatic about the risks out there. And my job is to make sure that you, as a founder, as an entrepreneur, understand those risks. I'll give you my best assessment of that risk, and I'll be able to tell you, look, I wouldn't really worry about this too much. I want you to know it's out there. Or, we really have to spend money and time worrying about this because this could really hurt us down the road. So the founder, the entrepreneur, needs to have that assessment of the risk and needs to understand the probability and the magnitude of that risk. Ultimately, it's the founder's decision. My goal is to help them get there, to understand that. And it's basically seeing repeat facts over time, seeing situations either blow up or not, depending on how they evolve. Great communication skills between the lawyer and the entrepreneur and their investors are fundamental, are absolutely fundamental. And keeping everyone in the loop, Esteban said it about keeping people informed about your company's progress. The same holds true to keeping your lawyer informed about the company's progress as well. And just making sure you have a good, pragmatic, business-oriented lawyer who who's not so risk sensitive that the sky is falling all the time. Because there's plenty of successful companies that have navigated all these issues, have dealt with them, and have done so in a way that everyone has benefited.
So, considering all the things that can be done, what would be like a short list of things to must do, and probably the right order to do and the right time to do them, considering the limited time and resources one has?
Sure. So usually at the top of the list is forming the company, whether that be a hybrid model, whether that be in your home country. And in line with that is where are you going to have your operations, where are you going to fundraise, where are you going to have your employees, because those are the questions that you need to answer to determine what's the best structure. In line with that is that's the first step, setting the house up, building the house, and then populating the house, making sure you have IP owned by that company, getting your equity, your owners of the house in order, making sure all that's documented, getting a trademark on file, getting the URL names and the URLs and the name of the company. Any patent filings that need to be made should be made in the name of the company and not any founders, because founders can come and go. The company is going to have the staying power. So that's kind of second step. And then, documenting employee arrangements comes soon thereafter. Advisor arrangements, consulting arrangements, and then, of course, the fundraising. That's your typical step-by-step process.
Can you talk a little bit more about the advising relationships?
Yeah.
Because you can have an advisory team who's just advising you on a volunteer basis.
Sorry, I'm going to use a microphone so that the audience don't miss the information in the question.
Sure.
Okay? So just raise your hand and then
Thank you.
help.
My question is, can you talk more about the advisory roles? You can have an advisory team that's on a volunteer basis, and then you have advisors who are much more involved. You can differentiate between the two, and what agreements you need to establish with both.
Sure. So there's two different types of advisors. You're absolutely right. There's kind of informal advisors, mentors, friends, other folks in the community that are helping you out. And then when lawyers talk about advisors, it's usually your formal advisors. And what that means oftentimes is you've got an advisory agreement in place where they commit to giving you a certain amount of time, making introductions, participating in formal advisory board meetings, any number of ways that they can help you. That gets formalized and documented. You need to be very clear what your expectations, participating in formal advisory board meetings,